No humans were harmed or even used in the video creation of this program. I created it from a script I wrote using a generative artificial intelligence platform and my own avatar of me. We hope you enjoy it. You see it everywhere, made in America. But what laws govern the use of this claim in commercial products? Hello and welcome. My name is Peter Afrasiabi. I am an intellectual property litigator at the law firm of One LLP with offices in Newport Beach and Los Angeles, California. My practice focuses on copyright, right of publicity, trademark, and related privacy torts. I also teach as an adjunct at the University of California Irvine School of Law, where I teach a Ninth Circuit Appeals litigation clinic with my students, as well as an advocacy and persuasion course. I have taught advocacy at the National Institute of Trial Advocacy and taught advocacy to new barristers at Oxford University in England. But keep in mind, all of the views expressed in this video are mine and mine alone, and are not the views of my law firm, the university, or any other academic institution or entity I work with. Today's program is a Curious Lawyer series program on this topic. When can you make the Made in USA claim, and when not? For a product to be called Made in USA or claimed to be of domestic origin without qualifications or limits on the claim, the product must be all or virtually all made in the US. We will explore today what that means and how it works. But first and briefly, I want to tell you more about the Curious Lawyer series that we have created for you, a true curious lawyer. The Curious Lawyer series is a fun, educational, and entertaining walk down some of the off-the-beaten paths of law, areas that you do not experience in your regular practice day to day, but which are incredibly interesting and informative, and often yield new insights and valuable analogies or metaphors that you can work with in your practice. They also give you new general legal information for your clients. In this series, we take a variety of interesting issues and intersect them with the law to find fascinating, new, educational, and informative areas of the law to explore and to better educate you about legal areas you may not know. For example, we have done programs on dog law where you get to think about your favorite furry friend and see how our relationship with dogs intersects the law, from tort to contract law, to even trusts and estate battles over dogs, and of course, Fourth Amendment cases where there have been warrantless removals of dogs from homes for violating the leash laws. Or you can see the CIA Law Program, where you will see fascinating legal topics related to the CIA secrecy and the Freedom of Information Act, and where you will learn about that famous Hollywood movie line, "I can neither confirm nor deny." You will learn where it came from, and it turns out it was not Hollywood, but you have to watch it to learn who came up with it. We have also looked at whether there's a little sliver of Yellowstone National Park where, due to a combination of the Sixth Amendment's vicinage requirements and the subsequent federal districts that were created by Congress to sit over the nation, whether that, in fact, has actually yielded a sliver of land in our famed Yellowstone that is free from federal criminal prosecution. We ask, is it a perfect crime zone? Listen to that program and you will find out. And if you want to brush up on the Bill of Rights, we have a 10-part series with 1 hour devoted to each of the first 10 amendments to the Constitution, so that you, at the next cocktail party, can answer when a non-lawyer asks you what one of the amendments is all about. The one thing the Curious Lawyer series is not is boring. This is most definitely not your typical continuing education. That is often technical, difficult, or stressful. So sit back and grab a cocktail, if you are so inclined, and let's get going in our fascinating walk into the heart of America and advertising American made. So first, here's what we are covering today, and we will stop along the way to give practice pointers for your clients that may be engaged in advertising around Made in America or Made in the USA claims, so that you can best prepare your clients to avoid trouble. To start, we will look at the governing federal and state laws that dictate use of the label Made in America or Made in USA claims. We will look at the substantive standards and requirements related to the claim. We will look at the remedies for violations, some very potent at the hands of the FTC. We will look at the FTC concerns that animate this issue of growing importance. and therefore we will look at the false advertising litigation cases over these issues. This lets us explore the governing substantive FTC standards and rules. We will look also at California private attorney general actions, as California has its own laws that regulate this issue for commerce in California. Then, we will look at class action lawsuits that have erupted in this area too. We will see some data on their growth, as well as some of the damages awards that have flowed from this kind of mislabeling. And we will look not just at FTC and class action exposure, but also competitor-on-competitor lawsuits, where these issues of use of Made in the USA or use of flags in advertising comes up in the vein of false advertising litigation under the Federal Lanham Act. As a sidebar, we will look at the Buy American Act also, an act that addresses government purchases of American products in procurement. And we will also look at federal flag guidelines that speak to the use of the flag in commercial advertising. And as we will see, there is a growing surge of cases against misuse of the Made in America phrase, and it has the full attention of President Trump and the FTC. So let's start with a short video from the chairman of the FTC on this very topic.
Hello, I'm Andrew Ferguson, Chairman of the Federal Trade Commission, the federal agency with primary responsibility for enforcing the laws that protect Americans from monopolistic and fraudulent business practices. In honor of our nation's independence, we here at the FTC are designated July as Made in the USA Month. As Chairman of the Federal Trade Commission, I am responsible for enforcing the laws that protect Americans from false or unsubstantiated claims that a product is made in the USA. It's important to protect Americans from deceptive advertising, but it's also important because it provides consumers with confidence that every time they buy a product that says Made in the USA, they are actually supporting American workers, American manufacturing, and American communities. In a recent poll, 61% of Americans said that whether a product is made in the USA is important to their purchasing decisions. Why? Because Americans rightly believe that American-made products are of higher quality and better for the environment than their foreign alternatives. But most importantly, it's because Americans want to support American workers, American manufacturing, and American communities. Unfortunately, many products, from common household appliances to complex pieces of machinery that could be advertised as made in the USA, are not. That's why we at the FTC have created an easy-to-read online guide for companies who wish to advertise their products as made in the USA. We want to enforce the law at the FTC, but we also want to help companies that want to showcase that their products are made by American workers and show that American manufacturing is an engine for innovation, growth, and job creation. To be made in the USA is not just a slogan, but a sign that a product connects us with the ingenuity, quality craftsmanship, and livelihoods of our fellow citizens. As we celebrate our nation's independence this month, let us also remember to celebrate the hard work, self-reliance, and pioneering spirit of our nation's workers and communities. When we buy a product that is made in the USA, we help keep alive that spirit that won us our independence and that makes our country great every day.
Okay, so that is an important message from our chairman on this topic, which we will come back to shortly in terms of how it illuminates this growing legal issue for us and our clients. Let's now get an overview of the legal framework and substantive rules. That is, the labeling framework. The labeling rule has codified the all or virtually all standard for labels on products. What this means is that marketers are now subject to civil penalties if they use an unqualified Made in USA label on a product that is not all or virtually all made in the US, including in catalogs or online. This all or virtually all standard means that for a product to be called Made in USA or claimed to be of domestic origin without qualifications or limits on the claim, the product must be all or virtually all made in the US. The term United States, as referred to in the Made in USA policy statement and the labeling rule, includes the 50 states, the District of Columbia, and the U.S. territories and possessions. The Made in USA policy statement applies to U.S. origin claims that appear on products and labeling, advertising, and other promotional materials. It also applies to all other forms of marketing, including marketing through digital or electronic mechanisms, such as internet, email, or social media. Finally, Other than some narrow categories, there is no affirmative obligation to so mark if a product is made in America. And we will look later at the affirmative labeling rules too for narrow categories related to clothes and cars. So let us first start with the law itself. Here is the code. The term made in the United States means any unqualified representation, express or implied, that a product or service or a specified component thereof is of U.S. origin, including but not limited to a representation that such product or service is made, manufactured, built, produced, created, or crafted in the United States or in America, or any other unqualified U.S. origin claim. And in subsection B, the terms mail order catalog and mail order promotional material mean any materials used in the direct sale or direct offering for sale of any product or service that are disseminated in print or by electronic means and that solicit the purchase of such product or service by mail, telephone, electronic mail, or some other method without examining the actual product purchased. End quote. Here is where we get the governing rule, subsection 323.2. In connection with promoting or offering for sale any good or service, in or affecting commerce as commerce is defined in Section 4 of the Federal Trade Commission Act, it is an unfair or deceptive act or practice within the meaning of Section 5, 1 of the Federal Trade Commission Act, 1, to label any product as made in the United States, unless the final assembly or processing of the product occurs in the United States. All significant processing that goes into the product occurs in the United States, and all or virtually all ingredients or components of the product are made and sourced in the United States. So from those codified rules, we get the key rule for you to remember. All or virtually all means that the final assembly or processing of the product occurs in the United States. All significant processing that goes into the product occurs in the United States, and all or virtually all ingredients or components of the product are made and sourced in the United States. That is, in short, the product should contain no or negligible foreign content. When a manufacturer or marketer makes an unqualified claim that a product is made in USA, it must have and must rely on a reasonable basis to support the claim. This means a manufacturer or marketer needs competent and reliable evidence to back up the claim that its product is all or virtually all made in the U.S. Companies have an ongoing obligation to review their claims and substantiation to make sure they remain accurate. If something changes and the company no longer has a reasonable basis to support its made in the USA claim, for example, the company begins sourcing parts overseas, the company must update its marketing materials. Now let's look at the FTC factors to make this calculation. First, the product's final assembly or processing must take place in the U.S. The FTC then considers other factors, including how much of the product's total manufacturing costs can be assigned to U.S. parts and processing, how far removed any foreign content is from the finished product, and the importance of the foreign content to the product's form or function. Costs don't tell the whole story. In some instances, only a small portion of the total manufacturing costs are attributable to foreign processing, but that processing represents a significant amount of the product's overall processing. The same could be true for some foreign parts. In these cases, the foreign content, processing, or parts is more than negligible, and as a result, unqualified claims are inappropriate. How does this then play out? We can now look at some examples from the FTC. Here's one example as published by the FTC. A company produces watches at a plant in Nevada using mostly U.S. parts and labor. All watches include movements, which are the parts that allow the watch to keep time. The company uses inexpensive Swiss movements in its watches. Movements account for a small proportion of the costs to make the company's watches, but without the movements, the watches can't tell time. Because movements are essential to the watch's function, an unqualified made in USA claim is likely deceptive. Here is another example. A table lamp is assembled in the U.S. from American-made brass, an American-made Tiffany-style lampshade, and an imported base. The base accounts for a small percent of the total cost of making the lamp. An unqualified Made in USA claim is deceptive for two reasons. The base is not far enough removed in the manufacturing process from the finished product to be of little consequence, and it's a significant part of the final product. And here is a third example. A company promotes its product in an ad that features a manager describing the true American quality of the work produced at the company's American factory. Although there is no express representation that the company's product is made in the U.S., the overall or net impression the ad is likely to convey to consumers is that the product is of U.S. origin. And there is the citation for you to see more examples if you want to look at some others. Now, another marketing or advertising tagline is "Assembled in America." How does this work? A product that includes foreign components may be called "Assembled in USA" without qualification when its principal assembly takes place in the U.S. and the assembly is substantial. For the assembly claim to be valid, the product's last substantial transformation also should have occurred in the U.S. That's why a simple screwdriver assembly in the U.S. of foreign components into a final product at the end of the manufacturing process doesn't usually qualify for the "Assembled in USA" claim. Let us look now at two examples from the FTSE on either side of this line, and these are worth exploring because some may be quite surprising. So example 1, a lawnmower composed of all domestic parts except for the cable sheathing, flywheel, wheel rims, and air filter, 15 to 20% foreign content, is assembled in the US. An "Assembled in USA" claim is appropriate. On the other side, here is example 2. All the major components of a computer, including the motherboard and hard drive, are imported. The computer's components then are put together in a simple screwdriver operation in the US, are not substantially transformed under CBP's standard, and must be marked with a foreign country of origin. An "Assembled in US" claim without further qualification is deceptive. Now what if a company has a qualified Made in USA ad? Something like "Made in America with foreign parts"? How do the rules work for that? The FTC has spoken here too. Here is the legal standard. A qualified Made in the USA claim may be appropriate for products that include US content or processing, but don't meet the criteria for making an unqualified Made in USA claim. Because even qualified claims may imply more domestic content than was actually used to manufacture the product, exercise care when making these claims. That is, avoid qualified claims unless the product has a significant amount of US content or US processing. A qualified Made in USA claim, like an unqualified claim, must be truthful and substantiated. And so here is an example offered by the FTC. A treadmill is assembled in the US. The assembly represents significant work and constitutes a substantial transformation. All the treadmill's major parts, including the motor, frame, and electronic display, are imported. A few of its incidental parts, such as the handlebar covers and the plastic on-off power key, are manufactured in the US. Together, these parts account for approximately 3% of the total cost of all the parts. Because the value of the US-made parts is negligible compared to the value of all the parts, a claim on the treadmill that it's made in USA of US and imported parts is deceptive. A claim like "Made in US from imported parts" or "Assembled in USA" would not be deceptive. Violating these laws and rules of the FTC is serious, as the remedies can be quite potent. Here is the rule of law. Any violation of this part shall be treated as a violation of a rule under Section 18 of the Federal Trade Commission Act regarding unfair or deceptive acts or practices. These are, in fact, serious federal remedies. Civil penalties of tens of thousands per violation and damages. Let's look at one recent case involving Williams-Sonoma. Here, Williams-Sonoma listed multiple products for sale as being "Made in USA," when in fact they were made in China and other countries. The FTC sued Williams-Sonoma in 2020, charging that the company advertised multiple product lines under its Gold Touch Rejuvenation, Pottery Barn Teen, and Pottery Barn Kids brands as being all or virtually all made in the USA when they were not. As alleged by the FTC, in 2018, the Commission received reports that respondent disseminated internet advertisements and promotional materials for Pottery Barn, teen organic mattress pads, stating those products were crafted in America from local and imported materials. When consumers purchased the mattress pads, they discovered that the pads were, in fact, made in China. And there you see an inner insert label prominently stating Made in China. So the FTC reached out to the company, and it quickly updated its website to include correct country of origin information for this product. As part of the FTC's inquiry, the FTC instructed respondent to undertake a larger review of its country of origin verification process. Now, the Williams-Sonoma company said this was an isolated instance of human error and committed to a multi-step verification process to prevent deceptive country of origin claims. As a result, the FTC staff closed its investigation with a letter on the public record in lieu of formal enforcement action. But then the FTC received a report that despite Williams-Sonoma's statements leading to the staff's closing letter, that it in fact continued to disseminate advertisements and promotional materials, including through its website and social media platforms, which deceptively claimed certain categories of Williams-Sonoma products were all or virtually all made in the United States. And so the FTC brought a formal claim to address this. And when the dust settled, this led to a record civil penalty of $3.175 million as part of a settlement. This is not an isolated case either, as FTC enforcement here has picked up with more multi-million-dollar settlements. Here are a few examples. In one case, the FTC pursued Instant Brands, manufacturer of Pyrex brand kitchen and home products, for falsely claiming that all its popular glass measuring cups were made in the United States during a time some measuring cups were imported from China. The company settled and paid fines, where the FTC then sent consumers the payments for the kitchen products. In another, Kubota North America Corporation paid a $2 million civil penalty as a result of a Federal Trade Commission action against the company for falsely labeling some of its replacement parts as being made in USA. There, the FTC alleged that, since at least 2021, Kubota has labeled thousands of replacement parts as made in the USA when in fact they were wholly imported. There you see on the screen their label, and as the FTC alleged, the parts were in fact wholly imported. In our final example to look at, Exodo sold mugs, glasses, pens, and other novelty items. As the FTC alleged, the defendant claimed, quote, "All of our products are made right here in the United States of America," end quote. But as the FTC alleged, in multiple instances, the products were wholly imported from China. And this led to a FTC order that imposed over $4.5 million in liability damages, a payment obligation, and the ability to suspend part of it upon milestones. The important point here, again, is that the exposure is very significant for errors, and so internal controls are critical to make sure advertising is accurate. So here we can distill our best practice tips for advice to clients. First, Made in USA claims must be truthful and substantiated before they are made. This requires competent and reliable evidence to back up all reasonable interpretations of the claim. Second, create a corporate centralized approval process for claims to prevent marketing mistakes, especially if a client business has multiple departments or teams that are responsible for creating and releasing content. Third, when relying on information from suppliers about the domestic content in parts, components, and other elements they produce, request specific information about the percentage of U.S. content before making any claims in advertising. Fourth, maintain records to support claims, especially as supply chains change in parts and fabrication, which may change the viability of the claim in real time in clients. Under the Tariff Act of 1930, codified as 19 U.S.C. Section 1304, foreign goods imported into the U.S. must be marked in a conspicuous place, in such manner as to indicate to the ultimate purchaser in the United States the English name of the country of origin of the article. And for food and agricultural products, the Farm Security and Rural Investment Act of 2002 and later amendments created mandatory country of origin labeling for specific agricultural food items. For most imported articles, the marking requirement applies. If the article is of foreign origin, that is, manufactured, produced, or grown abroad, and is imported into the U.S., then unless exempted, it must be marked with the English name of the country of origin. This means at the retail level, certain foods sold must display country of origin information. In 2015, the mandatory labeling for beef and pork was repealed following a WTO ruling that the U.S. approach was inconsistent with its trade obligations. Currently, there is ongoing regulatory and legislative discussion about tightening Made in USA origin claims for meat, poultry, eggs to avoid misleading claims. This does not mean meat producers in America must affirmatively label Made in America, as it is not a mandatory domestic stamping requirement. But if they choose to so label, then they must not run afoul of the Made in America rules we have been discussing today. Thus far, we have been looking at the issue of companies using the Made in America label so as to aid their sales and the legal regime that controls the use of the claim. But it turns out in certain instances it is legally mandated to state that. This brings us to the Textile Fiber Products Identification Act and the Wool Products Labeling Act. These acts require a Made in USA label on most clothing and other textile or wool household products if the final product is manufactured in the U.S. of fabric that is manufactured in the U.S., regardless of where materials earlier in the manufacturing process, for example raw fiber, came from. A textile or wool product partially manufactured in the U.S. and partially manufactured in another country must be labeled to show both foreign and domestic processing. And this mandatory notice to consumers also applies in the auto context. Specifically, the American Automobile Labeling Act requires that each automobile manufactured on or after October 1, 1994, for sale in the U.S. bear a label disclosing where the car was assembled, the percentage of equipment that originated in the U.S. and Canada, the names of countries other than the U.S. and Canada, contributing at least 15% of the average overall percentage of equipment on vehicles within the car line, and the country of origin of the engine and transmission. Any representation a car marketer makes that is required by the Act is exempt from the Commission's policy. When a company makes claims in advertising or promotional materials that go beyond the Act's requirements, it will be held to the Commission's standard. Let's see the rules in their specific language now. Auto manufacturers must provide the following information generally to consumers. 1. U.S. Canadian parts content. The overall percentage by value of the passenger motor vehicle equipment that was installed on vehicles within the car line of which the vehicle is part, and that originated in the United States and/or Canada. 2. Major sources of foreign parts content. The names of any countries other than the United States and Canada which contributed at least 15% of the average overall percentage by value of the passenger motor vehicle equipment installed on vehicles within the car line of which the vehicle is part, and the percentages attributable to each such country. If there are more than 2 such countries, the manufacturer need only provide the information for the 2 countries with the highest percentages. 3. Final assembly point. The city, state, in the case of vehicles assembled in the United States, and country of the final assembly point of the passenger motor vehicle. 4. Country of origin for the engine. The country of origin of the passenger motor vehicle's engine. 5. Country of origin for the transmission. The country of origin of the passenger motor vehicle's transmission. And 6. A statement which explains that parts content does not include final assembly, distribution, or other non-parts costs. And it turns out, car companies have been sued under this law. In 2025, a plaintiff in Ohio sued General Motors, claiming GM is making false and deceptive Made in USA claims on its AC Delco product packaging. AC Delco is part of the GM parts business. The plaintiff claims that he bought an AC Delco transmission filter because the box said Made in USA. But as he alleges, he found the part itself stamped Made in China. This is a class action suit, and we have to stay tuned to see how it plays out. But it is a real-world example of the importance of making sure that product labeling as it relates to Made in America claims is done carefully and accurately. So we have thus far looked at federal law. But let's now look at state laws that touch this area. And California and its Business and Professions Code is one area of state regulation. This code section prohibits Made in USA claims if any significant part is made outside the U.S. Here is the rule of law. It is unlawful for any person, firm, corporation, or association to sell or offer for sale in this state any merchandise on which merchandise or on its container there appears the words Made in USA, Made in America, USA, or similar words if the merchandise or any article, unit, or part thereof has been entirely or substantially made, manufactured, or produced outside of the United States. Now, there was a 2015 amendment to this law which provides clarification that merchandise that is manufactured or produced in the U.S. with foreign-made articles, units, or parts that bears a domestic label can be sold in California, if the foreign parts do not constitute more than either 5% of the final wholesale value of the product, 10% of the final wholesale value of the product if the foreign parts are not available in the U.S. and the manufacturer cannot manufacture the part at issue. Before these amendments, merchandise sold in California could not bear domestic markings on its labeling or packaging if any component part was made outside the U.S. This standard was more stringent than the standards of every U.S. state and those of even the Federal Trade Commission, which, as we have seen, requires that all or virtually all of a product's parts must be domestically manufactured to use the label. But now, California has loosened the standard a bit. And here we can look at some case law to see how these standards have played out. Here we have a 2006 case from before those 2015 amendments we just saw, but it is illustrative and worth diving into. The facts are as follows. Plaintiffs were representative members of a class of persons in California who purchased Leatherman tools. Leatherman manufactures handheld, multi-component, multi-function tools comprised of components such as screwdrivers, pliers, saws, files, corkscrews, clip plates, locking tees, and bit holders. Leatherman offered for sale and sold 22 tool products in California and represented on the tool products, on packaging, and in advertising that the tools were made in the United States. The trial court considered the importance of the foreign processed parts to the tools as a whole and held, defendant argues that the tools were assembled in the United States and that only a few parts were made outside the USA. The problem is that those few parts are the significant parts of the tools, why the people buy them. The jaws, saws, files, knives, corkscrews, and Phillips screwdrivers are made in whole or in part outside of the United States. For the court, that is the guts of the tools. Going deeper into the facts to understand that holding, the court found that the components incorporated into the Leatherman tools at issue underwent manufacturing processes outside the United States. These components included a file that was fine blanked in Switzerland and that had its teeth cut and hardened in Switzerland or Austria, plier jaws, Phillips screwdrivers, bolster file sides, and bolster knife sides that were investment cast in Mexico, a clip plate that was fine blanked, deburred, formed, hardened, and polished in Switzerland, a locking tee that was fine blanked and hardened in Switzerland, a bit holder that was machined in Canada, a saw blade that had its profile cut in Switzerland or Germany and that was fine blanked and hardened in Switzerland, handles that were fine blanked in Switzerland, a serrated knife blade that was fine blanked in Switzerland, and corkscrews that were forged, coiled, hardened, and polished in France. So on appeal, here is what the California Court of Appeals held. While Leatherman argued that the Made in USA description was not deceptive because the products were designed, engineered, assembled, and finished in the United States, and thus were not substantially made outside the United States. The evidence that is not in dispute establishes that a significant portion of the various parts of the products were manufactured abroad. A reasonable consumer of Leatherman's products with the Made in USA representation would not expect such foreign manufacturing. A product may not be represented as made in USA if the product itself, or any article, unit, or part thereof, has been entirely or substantially made outside of the United States. No reasonable trier of fact could find that the goods were not substantially made, manufactured, or produced abroad. This comes from those reference pages if you want to dive into the case yourself. The important takeaway is that just because something is designed, engineered, assembled, and finished in America does not allow one to blanket claim it is made in America, where a significant portion of the various parts of the products were manufactured abroad. The focus is on consumer perceptions, and the courts are strict in hewing to that consumer protection line in the case law. Here are two more cases addressing standing and the scope of class actions in this context to bring these claims against private companies. The first case is the Kwikset case you see cited there. The basic facts are that defendant manufactured lock sets it labeled as Made in USA. The plaintiff's lawsuit challenged the label's veracity. The Supreme Court granted review to address the standing requirements, as the lower courts had dismissed at the pleadings for lack of standing. The Supreme Court held that plaintiffs, who can truthfully allege they were deceived by a product's label into spending money to purchase the product, and would not have purchased it otherwise, have lost money or property within the meaning of California's unfair competition laws. Now, standing is met there, but let's look at this case on the scope of a potential class in a Made in the USA case. This is the case involving Target stores you see cited there. Here is what happened. Information on Target's website stated that the clothing items had been made in the United States. When the items were delivered, the consumer discovered that the items had labels showing they were made outside the United States. He alleged that he had relied on the country of origin information in making the decision to purchase the items, and he filed a class action. Now, Target presented evidence that a computer programming error had caused inaccurate information to appear under a particular tab, that the majority of customers had not clicked on the tab before making their purchases, and that it would be impossible to determine which of the remaining customers had seen the mislabeling without asking each of them individually. This, then, was a challenge to the ability to make the labeling advertising error a basis for a class instead of an individual-based lawsuit. The court affirmed the trial court's conclusions that the evidence did not establish an ascertainable class, and that the proposed class was therefore overbroad, because most class members lacked standing. Now we can also see class actions against companies as they progress through standing and get to the merits. Here we have the case of Kimberly Banks versus R.C. Bigelow from the Central District of California. This involved a California federal court suit against Bigelow Tea, alleging false representations that teas are made in the United States when the tea leaves are grown and processed abroad. The term manufactured in the USA was on the back of packaging. At trial, the plaintiff's expert testified that survey evidence to measure the economic value on manufactured in the USA and concluded that American consumers valued it such that they overpaid by 11.3%. That amounted to $3.26 million. And the jury awarded $2.36 million in damages. What is particularly interesting about this case is the expert analysis that concluded the value of the tagline "Made in America" is significant to consumer purchases. The claims we have seen are not isolated. The FTC also in 2025 found that tractor maker Kubota North America Corp. Had to pay a $2 million civil penalty for falsely labeling some of its replacement parts as being made in USA. There, the FTC sued, arguing that since at least 2021, Kubota had labeled thousands of replacement parts for its tractors and other agricultural equipment as made in USA, even though they were made entirely overseas. In addition, after the company moved manufacturing for some parts to other countries, it failed to update the product's labeling to reflect that change, leaving them labeled as Made in USA, according to the complaint. Kubota entered a stipulated injunction for $2 million and other injunctive relief. Here is why I flagged that case for you. It appears that as of 2025, class actions in this space are on the rise. Here is some data. There were 7 class actions on these types of claims in 2024. But by mid-2025, there are already 13 class actions. And recall, since 2021, the FTC has brought several actions and collected over $15 million. We saw some of those cases already. Further, July 2025 was Made in the USA month as designated by the FTC, which is focusing on the issue now more, as we saw in that video earlier. Okay, so here is the official proclamation from President Trump in July 2025 that stands behind the renewed vigor from the FTC in this issue. Since the earliest days of our history, our nation's future has been forged by skilled American hands and proud American hearts. From the settlers at Jamestown to the titans of industrialization and manufacturing, America has understood that in order to be a great nation, we must be a nation that builds, creates, innovates, and fights for the needs of our own workers, families, and industries first. This Made in America Week, my administration recommits to furthering this legacy, and we pledge to embolden our workers, re-energize our industries, and bring back those beautiful words, Made in the USA. So, as well as the presidential focus on this and the value to consumers we saw in that expert testimony in the earlier case, it is safe to bet that more actions in this space will be filed. Indeed, in July 2025, the FTC even issued letters to Amazon and Walmart regarding third-party sellers who appear to be making deceptive Made in USA claims about their products on those online marketplaces. This is a means of exerting influence on resellers to get them to force compliance. In short, it is an issue that matters more today than perhaps ever before in terms of legal awareness and readiness for our clients. But what if one uses a flag without the words Made in America? This brings us to another aspect of advertising Made in America, and it comes from U.S. flag law. And it turns out, there is an entire federal set of federal guidelines related to flags, including, as we shall see shortly, the advertising of flags. So let's start with the federal law that addresses flags. Yes, you heard it here at The Curious Lawyer first. We have a detailed set of enactments in the U.S. Code relating to flags. So let's start here with a quick overview of the U.S. Flag Code, which is contained at 4 U.S.C. Sections 1 through 10. A quick framework is as follows. 1. This federal law regulating flags sets forth guidelines for private citizens and the government on the appearance and display and treatment of the U.S. flag. 2. It defines how a U.S. flag must look and display times, its use in processions and parades, and half-staff use rules. 3. It vests complete authority in the President to change code enactments. 4th, the Flag Code also specifies how to deliver the Pledge of Allegiance to the flag and appropriate conduct while watching a performance of the national anthem. And finally, most of the Flag Code contains no explicit enforcement mechanisms, rendering them more guidelines than federally enforceable standards. This will matter later when we look next at the federal guidelines that speak to no commercial use in distinction to the ubiquitous market use of the flag in commercial advertising. Now, as to advertising, here is what the code says. Any person who, within the District of Columbia, in any manner for exhibition or display, shall place or cause to be placed any word, figure, mark, picture, design, drawing, or any advertisement of any nature upon any flag, standard, colors, or ensign of the United States of America, or shall expose or cause to be exposed to public view any such flag, standard, colors, or ensign upon which shall have been printed, painted, or otherwise placed, or to which shall be attached, appended, affixed, or annexed any word, figure, mark, picture, design, or drawing, or any advertisement of any nature. Or who, within the District of Columbia, shall manufacture, sell, expose for sale or to public view, or give away or have in possession for sale, or to be given away or for use for any purpose, any article or substance being an article of merchandise, or a receptacle for merchandise or article or thing for carrying or transporting merchandise, upon which shall have been printed, painted, attached, or otherwise placed a representation of any such flag, standard, colors, or ensign to advertise, call attention to, decorate, mark, or distinguish the article or substance on which so placed shall be deemed guilty of a misdemeanor and shall be punished by a fine not exceeding $100 or by imprisonment for not more than 30 days, or both, in the discretion of the court. And the key definition says, quote, "The words flag, standard, colors, or ensign, as used herein shall include any flag, standard, colors, ensign, or any picture or representation of either, or of any part or parts of either, made of any substance or represented on any substance, of any size evidently purporting to be either of said flag, standard, colors, or ensign of the United States of America, or a picture or a representation of either, upon which shall be shown the colors, the stars, and the stripes, in any number of either thereof, or of any part or parts of either, by which the average person seeing the same without deliberation may believe the same to represent the flag, colors, standard, or ensign of the United States of America." End quote. Wow. So as you can see, there is a fine power of the prosecutors to punish the use of the flag in advertising. We ask, can this law stand as against the First Amendment? First, no court has directly addressed whether the use of a U.S. flag in advertising is commercial speech. This makes the answer uncertain. Second, the question is, does the flag add to expressive content of commercial advertising and convey any information about a product service? One difficulty in analyzing this issue is that the display of a flag in advertising appears to add little expressive content to the commercial aspects of the advertisement. In other words, while a U.S. flag may be used in an advertisement and its use may be economically motivated and thus commercial speech, the display of a flag is unlikely to convey information about the specific product or service. Rather, the expressive content of displaying the flag would appear to be to link the product or service to a political message such as patriotism or national pride. Thus, even with lower First Amendment protection for commercial speech, it likely would be lawful to use the flag. For instance, while concerns about avoiding a breach of the peace is a substantial governmental interest, it seems unlikely that, given Supreme Court commercial speech law, the court would find that prohibiting using a flag for commercial advertising was intended to avoid a breach of the peace, or any idea about preserving the physical integrity of a privately owned flag would be unlikely to be a sufficient government interest to outweigh the suppression of expressive advertising conduct. And moreover, if the concern is false advertising or fraudulent representations in commerce, then we already have myriad laws that allow action on that to enjoin violations consonant with the First Amendment. Finally, this code section is a set of guidelines and has not been enforced through an action by the government ever as against commercial use in the envisioned misdemeanor criminal context, and so any future action would certainly be met with First Amendment challenges. But if the use of a flag to imply something is made in America when it is not, one can imagine the FTC or class action lawyers bringing an action on an implied representation theory. Under the Made in America laws, we have looked at and perhaps adding this law to the mix to stop implied misrepresentations. Indeed, the FTC already envisions this issue. It has stated as follows in its guidance on implied claims. Quote, "In identifying implied claims, the Commission focuses on the overall net impression of an advertisement, label, or other promotional material. This requires an examination of both the representation and the overall context, including the juxtaposition of phrases and images, and the nature of the transaction. Depending on the context, U.S. symbols or geographic references, such as U.S. flags, outlines of U.S. maps, or references to U.S. locations of headquarters or factories, may, by themselves or in conjunction with other phrases or images, convey a claim of U.S. origin. For example, assume that a company advertises its product in an advertisement that features pictures of employees at work at what is identified as the company's U.S. factory. These pictures are superimposed on an image of a U.S. flag, and the advertisement bears the headline, "American Quality." End quote. The best practice pointer is, if something is not made in America, do not use a flag instead to try to avoid the FTC laws we looked at, because that use of a flag contextually may imply the product is made in America, Now, in one Tenth Circuit case, the court looked at some of this through the prism of the Lanham Act, where you have competitor on competitor litigation over false advertising, and let's see what it said. Big picture. Here is a quick overview of the federal Lanham Act as it applies as between companies suing each other over their advertisements. This is known as federal false advertising. This claim targets deceptive commercial statements about one's own or another's products. A plaintiff must prove 1. A false or misleading statement of fact in a commercial advertisement or promotion. 2. Deception or tendency to deceive a substantial portion of the intended audience. 3. Materiality, which means the deception is likely to influence purchasing decisions. 4. The product was placed in interstate commerce. And 5. Injury to the plaintiff. Now, showing a false advertisement is not enough, as this is a consumer-centric law that focuses on establishing proof that consumers were misled or deceived. So, with that background, this is the case of iDig Texas versus Krieger from 2024, reported at 98 F. 4th 998. These claims mainly involved the advertisements encouraging consumers to buy products that are American-made. At issue is the truth or falsity of the characterization of products as American-made. Is a boast about American-made products literally false when the business assembles products in the United States but uses some foreign components? Here are the core facts. Some products had been assembled in the United States, others in China. Even for the products that iDig Texas had assembled in the United States, some components had come from overseas. For example, iDig Texas had used a nitrogen power cell made in China, and some of the nuts and bolts had come from Canada. Now let's see what the 10th Circuit held. It ruled that the statements were not actionable because the boast itself was ambiguous because, quote, the term make could refer either to the origin of the components or to the assembly of the product itself. For example, if Chrysler says that its cars are American-made, someone might regard the statement as truthful if Chrysler assembles the cars in the United States, even if some components came from overseas. End quote. That is page 1010, by the way. And as to the use of flags to imply American-made, Krieger also argued that iDig Texas used patriotic symbols like an American flag to imply that the products had been made in the United States. It held, quote, granted, patriotic symbols could imply that the products were American-made. But the symbols couldn't objectively be verified as true or false. As a result, the use of American symbols was ambiguous and couldn't render the advertisements literally false, end quote. That is from page 1012 of the opinion. Let's do one final sidebar here since this program is about buying American. And this brings us to the Federal Buy American Act. This act was the first of the major domestic content restriction laws, and it requires federal agencies to apply a price preference for domestic end products and use domestic construction materials for covered contracts performed in the United States. The law encourages federal agencies acquiring supplies for use in the United States under a contract valued in excess of a monetary threshold called the micro-purchase threshold, typically $10,000, to purchase domestic end products instead of foreign products. Now, there are, as with all our laws, it seems, exceptions. For example, the agency can simply waive the requirement for public interest. Also, the law doesn't apply if the agency determines the product really isn't available in substantial quantities in the United States. Furthermore, the agency for a procurement matter can determine that, for that specific procurement, that the item in question isn't really available in the United States. Further, if the offered cost of a domestic end product is unreasonably low, then the agency can find that the law does not need to apply to that transaction. So, what is the point? Federal spending has preference for domestic-made goods unless the price is unreasonable. This is another part of the Made in America mosaic of laws that we are looking at as they relate to public and private conduct. As a final practical pointer to give your clients on this Made in America program, there are now developed SBA loan programs for small businesses built around the Made in America concept. These are new programs that your clients may not know about and may have value to their development and manufacturing projects. Here's a quick video from the SBA on it, so you can also flag it. No pun intended, given our flag discussions here today.
Hi, I'm Lisa Shimkat with SBA's Office of Field Operations and the Office of Manufacturing and Trade. I'm here today to talk about some exciting financing opportunities that are available to all small U.S. manufacturers. The U.S. Small Business Administration is dedicated to restoring America's manufacturing capacity through Administrator Loeffler's Made in America Manufacturing Initiative. The goals of this initiative are simple. They include cutting regulations, expanding access to capital, and creating a dedicated infrastructure to support small manufacturers through our new Office of Manufacturing and Trade. We'll be sharing information on how manufacturers can use SBA's loan programs to take their business to the next level. I encourage you to follow us on social media to stay up to date on all of our resources. For more information on how SBA can help your manufacturing business, please visit us at sba.gov/manufacturing or contact your local SBA district office.
Let's wrap up then with a recap and review of the key points to take away with you. First, the governing rule itself. Remember, the labeling rule codified the all or virtually all standard for labels on products. What this means is that marketers are now subject to civil penalties if they use an unqualified Made in USA label on a product that is not all or virtually all made in the US, including in catalogs or online. This all or virtually all standard means that for a product to be called Made in USA or Made in America or claimed to be of domestic origin without qualifications or limits on the claim, the product must be all or virtually all made in the U.S. All or virtually all means that the final assembly or processing of the product occurs in the United States. All significant processing that goes into the product occurs in the United States, and all or virtually all ingredients or components of the product are made and sourced in the United States. That is, the product should contain no or negligible foreign content. And remember, the product's final assembly or processing must take place in the United States. The FTC then considers other factors, including how much of the product's total manufacturing costs can be assigned to U.S. parts and processing, how far removed any foreign content is from the finished product, and the importance of the foreign content to the product's form or function. And remember, this also can apply to implied misrepresentations, such as opaque language or deceptive uses of the flag to imply things are made in the USA. So, for your clients, the key takeaways are as follows. First, Made in USA claims must be truthful and substantiated before they are made. This requires competent and reliable evidence to back up all reasonable interpretations of the claim. Second, create a corporate centralized approval process for claims to prevent marketing mistakes, especially if a client business has multiple departments or teams that are responsible for creating and releasing ad content. Third, when relying on information from suppliers about the domestic content in parts, components, and other elements they produce, request specific information about the percentage of U.S. content before making any claims in advertising. Fourth, maintain records to support claims, especially as supply chains change in parts, which may change the viability of the claim in real time for your clients. And fifth, I would add, be alert to problems if you are reselling third-party products, as their claims may be fake, and you need to take steps to ensure they are doing things properly. This goes to the FTC letters sent to Amazon and Walmart that I referenced earlier. From a liability perspective, as we saw, the stakes are high. The FTC can demand staggering penalties per violation, which can be existential potentially. And as we addressed, this is an area that the FTC is now monitoring and acting in more than before, so you can expect your clients to face more and more potential federal scrutiny. We looked at the really large fines by companies that trip these rules. And, of particular concerns to potential clients of yours, this has become a growing cottage industry for class actions. We looked at the data on the growing number of cases in the space, which can yield large damages, settlements, and attorney fee exposure, of course. And as we saw, state laws regulate this area too, creating a dual world of potential exposure. Finally, we saw a third rail to this, which is competitors making federal false advertising claims to address competitors who may be false labeling and getting a competitive advantage. That case failed. but it does not mean other cases may succeed on different facts. In short, as we saw, Made in America or Made in the USA matters to marketing and business. Recall, as we saw in one published case, the plaintiff's expert testified that survey evidence on the economic value on manufactured in the USA and concluded that American consumers valued it such that they overpaid by 11.3%. That number was from years ago, and one can imagine that today experts could see the marketing claim as having even greater value. Thus, to avoid being on the receiving end of such claims, these Made in America claims should be done carefully and honestly. Thank you for watching. We really appreciate your viewing and hope you found it satisfying to your curiosity about our amazing, exciting wide world of the law. And as always, if you have questions, please email me.